Commonwealth versus Lezynski.
All right, let's proceed. Yes, good morning, counsel.
Good morning, Your Honors. May it please the Court, Thomas Foley for the defendant, Robert Lezynski. The sole issue on appeal is whether the improperly admitted toxicology results warrant reversal. The Commonwealth takes issue with the appeals court assumption that harmless error should be the standard. But with all due respect to my brother, the appeals court had it right. Harmless error should be the standard because the law, as it existed at the time of this trial, was that toxicology reports, just like drug certs, were admissible at that time.
But there was no statute, was there, that spoke of the admissibility of toxicology reports? It was just another expert's report.
Well, these were toxicology results. They were exactly like a drug cert in that they didn't fall into that statute, the drug cert statute, but they were exactly like drug cert results, which are just results from an analyst put on a piece of paper, which in this case were included.
Are they affirmed? In other words, is an analyst sign it saying, I affirm that these results are?
No, and they're different in that respect also, Your Honor. But
Thomas would think that would be a really important thing.
well, I'm looking more at the law as it existed at the time in the Commonwealth, and I'm looking really more to what this court said. And this court said toxicology results were admissible. In Commonwealth versus Nardi, I can read it. It was a medical exam, substitute medical examiner case, and in that case, the courts relied on Verde by saying that certain elements of the medical examiner's report, specifically those involving no judgment or discretion on the part of the medical examiner, like toxicology test results, may be admitted under the public records exception.
So do you think the toxicology reports would have been kicked out under Melendez-Diaz?
Oh, absolutely.
The fifth vote in Melendez-Diaz, you know, the deciding vote was Justice Thomas. And what was critical to Justice Thomas was that these drug certificates were done under oath, certified like affidavits, to which Justice Thomas said these clearly are testimonial. In those circumstances only.
I understand that, Your Honor, but I think just like the toxicology results in Nardi would have been kicked out even before Melendez-Diaz, I think Melendez-Diaz only strengthens the case.
All right, well, let me ask you this. You didn't object to the autopsy report going into evidence either.
Correct, Your Honor.
And that, Nardi says that was not admissible. That would be a confrontation clause issue.
Those are the exact same results that are at issue here.
Well, okay. I've got the autopsy report, which says cause of death is the acute fentanyl and ethanol intoxication.
Right.
That's right in the
autopsy
report.
And those are based on the NMS test results.
Whether they're based on that or not, it's right in the autopsy report, which you didn't object to either.
No, and I think, well, that's true, at which, of course, they would have been objected to if this case was tried after Melendez-Diaz.
Well, would they have been objected? You mean the autopsy report was admissible under Commonwealth versus Nardi?
Well, the reason I'm saying that the Commonwealth is arguing that it's not just the medical examiner's conclusion that fentanyl was present that renders the error here harmless. It's that the NMS test results are appended to the medical examiner's opinion, and therefore the medical examiner's testimony and. But
you didn't. Trial counsel did not object to the autopsy report coming in, which contains a very specific cause of death involving fentanyl. Yes. Didn't object to the death certificate coming in, which also contains a very specific cause of death reference to fentanyl. Isn't the reason those were not objected to is because the cause of death had nothing to do with this case. This case was all about whether the defendant provided the fentanyl to the dead person.
You're right that the primary defense was defending against the manslaughter charge. However, if this case had taken place after Melendez-Diaz, none of this evidence regarding fentanyl would have come in, and I don't even think the ME's conclusion would have come in, but none of the underlying test results would have come in. No basis for the opinion would have come in, so you would have had.
And your client was found not guilty
on the manslaughter,
of providing the fentanyl.
Well, I think he was found not guilty on that because the jury probably concluded that his conduct was not wanton and reckless.
So what relevance is the fact that there was fentanyl in the deceased person? What relevance is there between that and your client's conviction for possession with intent to distribute fentanyl?
I think that the fact that the medical examiner testified that there's fentanyl can be some evidence to prove that
your client had it?
Your
client was acquitted.
Well, they did find him guilty. So I think if you're gonna conclude that he's guilty of distributing because there's fentanyl in the system, I think you have to find some finding of fentanyl. The fentanyl patch wasn't found or tested. So the only proof.
Plenty of testimony that your client had fentanyl patches and was trying to sell them.
But even the appeals court didn't rely on that evidence to find harmless
They
error.
relied on the wrong evidence.
What was wrong with the evidence about all these people at the party that said, yes, he gave me one or he tried to give me one and I refused it and all that?
Because what we're looking at here is application of the harmless error standard. And by that standard, you have to find that that evidence was so overwhelming as to nullify the effect of those NMS test results.
Weren't the packages also in evidence?
There were some packages, none with my client's DNA were found on them, so I would argue that those
packages,
weren't. There were packages that were, the testimony was that my client found fentanyl patches in the garbage.
Right.
And then some weeks later tried to distribute them to people. But still, they have, just like in a crack cocaine case, you could have 30 individually wrapped rocks of crack cocaine, and you could have a police officer saying cocaine, it's cocaine, it's cocaine. But without that drug cert, without some toxicology results, it's not overwhelming evidence to overcome the powerful evidence of a drug cert. And that's what I'm arguing in this case. In this case, you had very powerful evidence that fentanyl was present in the decedent's bloodstream. And that was the NMS results.
Was there a drug cert for the fentanyl?
There was not a drug cert. In effect, the drug cert was the NMS toxicology results in this case. So in this case, when you've got the NMS results coming in saying this is absolutely 100% fentanyl in his system, and then you take that out because it shouldn't have been admitted in the first place, I don't think you can say finding some wrappers in the trash or
evidence that his coworkers, he tried to sell the fentanyl, which was packaged, by the way. This isn't cocaine packaged in a little clear baggie. These are the original pharmaceutical packages.
Right. Well, that's right. But I would argue that goes more towards his intent to distribute and does not prove the required element of proving that the substance was in fact fentanyl.
But there was not a single package that was tested at the drug lab, right?
That's right.
To determine whether this was fentanyl or
That's
not?
correct, Your Honor.
Okay.
Yes.
It was his own statement that it was fentanyl, and it was packaged
No,
as fentanyl.
Well, he did not testify. There was a statement that
Statements he made to others.
yes, there were statements that I have. Well, yes, he
And
said
fentanyl,
that.
would you like to buy some?
He found it in the garbage can. He doesn't know if it's what's in there. He doesn't know if it's degraded, how long it was sitting around before it was tossed out. He doesn't know if it's degraded. We don't know what was in that patch at this point. And again, you compare it to a drug case where, look, we know this is crack cocaine. You got 30 individual rocks. The guy's got them, in his mouth. The police see them, do a hand-to-hand, with them. We know it's crack cocaine, but this court and the appeals court routinely say, hey, until you prove that it's, and we need some kind of toxicology results or a drug cert to prove what the substance is, it's not enough.
So what was defense counsel's closing argument in this case? And more importantly, what was the prosecutor's closing argument? Did it have anything to do with whether or not this was really fentanyl?
No, Your Honor.
No.
Because
It was not an issue in the case.
Because the NMS drug results were in under Verde. Once they were in, there's no way the defense could have argued against it.
I think we have a case, maybe it's the appeals court, where there was a substance, it was not crack cocaine, but it was a pharmaceutical substance, and they were found outside of the Walgreens or some such with the indication on the bottle that it was something, and that was sufficient?
I'm not familiar with that case, Your Honor. I don't know if they. I would guess that those would have been tested in that case. In this case, they didn't have the patch, so they couldn't test the patch.
How is toxicology different from DNA analysis, where we have said that in the absence of an objection, it's a miscarriage of justice standard?
First of all, because this court said toxicology results in 2008, toxicology results are admissible under Verde. So they were admissible back then. I'm not sure whether DNA was admissible back then, before Melendez-Diaz. But to compare it to the medical examiners, for example, a medical examiner requires judgment, skill, discretion. So in those cases, it's like in Verde, this court concluded, no, you can't allow that sort of stuff in without the actual medical examiner testifying. But what you can allow in are things that take no discretion or judgment, such as toxicology results. So it was this court that said in 2008
And does toxicology results require less judgment or more judgment than
Yes,
a DNA analysis?
Because you're just, I don't know enough about DNA analysis, Your Honor, so I want to stay away from the DNA, but certainly compared to the Commonwealth's relying entirely on medical examiner cases. So I'm comparing
Actually,
it
that's
to the
not true. They cited Barbozo, which is a DNA case.
Well, they cited Housen, Sang, and Phim to say that the evidence in this case would have been admissible. And those are all medical examiner cases. This case falls under Nardi. It's toxicology results which don't require judgment and skill. Every toxicologist does the same exact test and then just reports the results. And that's why Verde found that, these drug certs were public records.
So your view is that the statutory allowance is irrelevant?
I wouldn't say it's irrelevant, but I think, as this court found in Nardi, you relied on Verde to say toxicology test results may be admitted under the public records exception. So I'm just going by the law as you pronounced it in 2008.
Yeah, but the fact that toxicology results and Verde saying that drug certs are are admissible under the public records law, and the Supreme Court says, well, at least with respect to drug certs, it's testimonial and you can't do it that way, doesn't necessarily mean the same goes for toxicology reports.
Well, you said it in 2008, Your Honor. This case took place 1 year after Commonwealth versus Nardi was decided. And in Nardi, you said toxicology test results may be admitted under the public records exception.
All I'm saying is that the Supreme Court's decision related to one piece of that, not to the other, and it may not necessarily follow that the other is covered by Melendez-Diaz.
I suppose, Your Honor. The Commonwealth, I really didn't prepare to argue that because the Commonwealth conceded it and the appeals court found it. It's really not, it really isn't the issue that has been presented here today. But I would certainly argue that toxicology results require an analyst.
But what is it that you're objecting to? I thought you were objecting to the testimony of the expert.
Yeah. I came in after this case was briefed, and it was focusing more on the testimony of the expert. Now, the Commonwealth they didn't, in their first brief to the appeals court, didn't raise the NMS results that were appended to the medical examiner's reports, which did come into evidence. And the appeals court didn't rely on those, on the NMS results that were appended to the ME's report, because it's the same exact evidence that was being challenged on appeal, the NMS test results. What the appeals court said was the medical examiner's testimony. The testimony was one brief reference. The toxicology came back positive for fentanyl. Now, you can take that and say, well, isn't that evidence? And I suppose I can't say that that's not evidence, even though we all know deep down, because we know where those results came from, that those results came from the NMS test results. Everything about fentanyl in this case, the finding of fentanyl, comes from that NMS test result.
But the pathologist can still rely on that in expressing his own or her own opinion. They're trying to eliminate all possible causes of death, and they've eliminated them all, except we have a lab report that comes back that says he had fentanyl in his system, and then I'm assuming, I haven't really studied the pathologist's report, but that the pathologist is opining that, notwithstanding the fact that he was reading it, look, I've excluded all other causes of death. The only thing that's left is fentanyl.
I'm not sure that the medical examiner said I excluded everything else. I think the medical examiner said, I know that fentanyl was found in this case, and fentanyl would cause this. And after looking at this, I find fentanyl, I found alcohol.
Well, did the pathologist say, look, I looked at the brain and all the other internal organs, and they were normal?
No, but they did find...
say that? The pathologist didn't testify to that? I'd be surprised.
I don't remember that specifically, but I do agree that, I'm not trying to argue that that wouldn't be the medical examiner's opinion. What I'm saying is that, look, when the medical examiner says the cause of death is fentanyl poisoning, that's highly relevant on the manslaughter charge. But on the distribution charge...
It's for all purposes.
Well, no, it's admissible for all purposes, but it's not powerful evidence on the distribution charge because
Guy died of fentanyl?
We know the medical examiner didn't do any fentanyl testing.
But she says that. She says it's my opinion he died of fentanyl. You've got all this other evidence of the event, that he has the patch, that he tears it open, that the girlfriend just puts her finger. I mean, there's plenty of evidence that the decedent took fentanyl, right?
Well, I would argue it's just like the crack cocaine cases when there's, I used to think overwhelming evidence. I actually, when Melendez-Diaz first came out and you weren't finding harmless error, or really more the appeals court wasn't finding harmless error, frankly, I agreed with you. I mean, 30 rocks of individually wrapped crack cocaine in the guy's mouth, making a hand-to-hand, getting the money, calling it cocaine. I mean, we all knew it was cocaine, right? Just like we all know that there was fentanyl in this case. But the fact is, it's one of the required elements of this case is to prove beyond a reasonable doubt that it was fentanyl. Just like in a cocaine case, you got to prove beyond a reasonable doubt that it's cocaine. Just like those cocaine cases when you ultimately found that all that kind of evidence wasn't enough without the drug cert. In this case, it's not enough without the NMS test results.
Counsel, your time is up. Thank you.
Thank you, Your Honors.
Good morning. May it please the Court. David O'Sullivan for the Commonwealth. I'd like to begin with what the Commonwealth believes is the critical issue, which is the standard of review here. And that requires us to look at whether an objection to Dr. Bohonik's testimony on direct examination concerning the specifics of hearsay on which he relied in forming his opinion was a meritorious objection under then existing law. Now, under long-standing Massachusetts evidentiary law, an expert witness may not, on direct examination, present the specifics of hearsay on which he or she has relied in forming their opinion. That rule was enacted in 1986 in the Department of Youth Services case and has been enforced ever since. Now, we know from this court in Grindeder, in the wake of Williams, that evidentiary rule actually provides potentially more protection than the federal confrontation clause does.
But what about, wasn't there a drug certificate admitted in this case?
There was not, Your Honor.
Okay.
No. So the question was whether that such an objection would be meritorious. Of course it would, given that existing Massachusetts evidentiary law. The defendant did not object and did not object several times in the course of the trial to similar evidence admitted not only in Dr. Bohonik's testimony, but in the medical examiner's testimony, Dr. Farrell Sandler, that neither of whom had personal knowledge of the presence of fentanyl in the decedent's blood, but neither of them objected on direct examination to the admission of that evidence, and the reason is clear. It's because it was a tactical choice to focus instead on as to the possession with intent to distribute indictment. And just to be clear, he was convicted of possession with intent to distribute, not distribution. With respect to that indictment, the defense theory was, of course, discrediting everyone who had claimed that the defendant had offered fentanyl by name to persons at the party. And with respect to the manslaughter indictment, the defense theory was, to the extent he did so, it was essentially the defendant's independent act in his choice to dabble in drugs.
The victims.
I'm sorry, the decedent, correct. The decedent's independent choice to dabble in drugs that resulted in his death. So essentially, that's a defense that challenges the causation element of the manslaughter indictment.
I assume because there was no drug cert, there was no instruction about, there was no sort of substituting the toxicology reports for a drug cert in that instruction, the kind of boilerplate instruction about you are entitled to but not required to find this as evidence that the stuff really was fentanyl.
Correct, no such instruction. And of course, no statute and no case made those admissible on direct examination. The defendant simply chose not to object for strategic reasons. Now, With respect to the evidence and the sufficiency of the evidence of the nature of the drug, Justice Duffley had mentioned an appeals court case, which I think is pertinent, though not regrettably cited in my brief. That case, I believe, is Alicia A., 56 Mass Appeals Court 311, 2002. In that case, there was circumstantial evidence sufficient to prove the nature of the drug. That drug was Klonopin. And in that case, the juvenile had told persons in her school that she was bringing Klonopin to school. There was testimony from the victim's, or from the juvenile's mother, that 17 Klonopin pills were missing from her prescription bottle. The juvenile showed a prescription bottle to her friends, and a doctor, and there was testimony concerning the specific appearance of that drug. It was a certain color, and it had a K stamped in it by a physician, which corresponded to the description of the drugs by the persons who saw it on the juvenile. That evidence, I would suggest, matches up quite well with the evidence in this case concerning the fentanyl transdermal patch, which, as Justice Cordy mentioned in his questioning my brother, we're not dealing here with nondescript powders. We're dealing with labeled prescription drugs in packaging, and in a particular form. This is a fentanyl transdermal patch, and there was, not only had the defendant offered this by name to several persons before and at the Christmas party, but Mr. McDonald had testified the defendant had actually given him, quote unquote, a fentanyl patch, which he had discarded the following day. Lee Hopkinson had testified that he had seen the defendant pass a patch to the decedent. And of course, Janest, who was familiar with fentanyl patches, knew persons who had taken them, knew it was for bone cancer, and knew that they were not meant to be ingested or licked, saw the defendant thereafter with a patch, saw him open that patch. And of course, there was packaging found not only on the counter, but in the dumpster next to the defendant's car. Now, some of that packaging, the DNA on it was found to be, the defendant was excluded as a contributor to that DNA, but there was other packaging in there as to which testing was inconclusive, and I would suggest that was also evidence the jury could use for not only the manslaughter indictment, but for the nature of the drug on the possession with intent to distribute indictment. If there are no further questions,
let me ask you a couple of quick questions. Today, assuming a trial today, autopsy report, well, let's forget the autopsy report, toxicology results in the same format that they were generated here are offered into evidence. Objection? What's the basis of the objection to those reports coming into evidence?
They're offered in the context of medical examiner's testimony on which something you relied on?
These reports are offered into evidence.
Hearsay. Objection. Yeah.
Objection, hearsay.
Yeah.
All right. Expert gets on the stand, like the expert here, and says the amount of fentanyl in the victim was lethal. The dose was lethal. That opinion okay?
Yes, Your Honor, I would submit
even
that
if the toxicology reports are not in evidence?
Even if the toxicology reports are not in evidence, what our evidentiary rule has said over time is that the specifics of hearsay information on which they relied is inadmissible on direct exam. That would permit the opinion that Your Honor mentioned. This was a lethal dose based on the expert's
So the expert would say what? I have reviewed the autopsy report, toxicology reports, other information, and in my opinion, the amount of fentanyl in the victim's body was lethal.
Yes, that would be permissible.
Wouldn't you need some evidence that the victim had fentanyl in his body?
Well, there's a question as to whether, of course, our evidentiary rule assumes that opinion and basis are severable, and only a bare opinion is admissible on direct examination. This is the kind of case where it's arguable that maybe it's not severable because of course, the medical examiner would have no personal knowledge of the presence of that drug in his blood. But I would say that he can, under our rule, state that there was a lethal dose of fentanyl in his blood without giving the specifics which came out without objection on direct examination here were that here are the levels of this drug fentanyl which are therapeutic. Here are the levels which were found in his blood, which are consistent with lethal outcomes, as they testified. That evidence needs to be left for cross-examination at the defendant's option.
Why couldn't the Commonwealth put in the toxicology results as medical records? Because I don't know where they were done.
Well, to the extent the toxicology results were done at a laboratory, not at a hospital. They were done at NMS labs in Pennsylvania.
That's right. Okay.
Yeah.
All right.
So, yeah, they wouldn't be admissible under Section 79 or Section 78, but they would be admissible with a proper witness.
You mean if you had somebody from NMS Labs say, "Yeah, I did the testing, and I mean these are part of our records." It's
correct, correct, and of course it's permissible in Massachusetts and in other places for an expert testimony to rely on hearsay matters.
Oh,
which
I
are
understand
not
that. I was just trying to figure out how you would get them the results directly into evidence.
Correct. It would have to be through an NMS witness, the NMS witness who performed the actual toxicology exam.
And is that because of Melendez-Diaz, or is that because of Crawford versus Washington?
That is,
It's because of Crawford.
to the extent Melendez is an outgrowth of Crawford, it would be because of Crawford. But
Just straight evidence, right? I mean, it would be the records themselves
Right,
are
it would be
hearsay unless
hearsay
there's some
also.
way to get them in, and the person that did it would be one way of getting them in.
correct. I mean, this court called those protections parallel ones. Not parallel. I'm sorry, consistent with in Barboza prior to Griner and Williams. As I said at the outset, in Griner, it's clear now after Williams that 5 justices of the Supreme Court would let that stuff in on direct examination, though for different reasons. So our rules provide more protection if a defendant chooses to invoke them for his benefit. Here he did not, because he had a very cogent theory of defense, which was successful in acquitting him of the lead charge in the case. If there are no further questions, I'd be happy to rest my brief.
Thank you, counsel.
Thank you.